Good morning, everyone. I would like to introduce you to Attorney David Cook, who will be providing today's training. David is a fourth generation Memphian with an undergraduate history degree from the University of Tennessee, Knoxville. He received his law degree from the University of Memphis. He has been practicing law in Memphis since 1977, specializing in medical and legal malpractice defense with the Hardison Law Firm, named for his mentor, Lee A. Hardison Jr., who taught him the vast importance of pro bono work. David has led the PALS elder law track since its inception. I am blessed and honored to have him as a mentor and a colleague. We are delighted to kick off our Pro Bono month with his seminar. Please, everyone who is here, join us in welcoming Attorney David Cook.
Thank you, Constance. Obviously, I have you fooled as I do everyone else, but that was very nice. I am an old geezer lawyer, and my specialty over the years was not estate planning and probate work. But having done pro bono work all through the years, I have had a lot of interactions with the types of clients that MALS deals with and that pro bono lawyers deal with. And I'm focusing pretty much on that today. The kinds of clients we're going to run into, the information we need to gather, and how to assist. And essentially, the bottom line is to avoid probate if it is at all possible, because it's time consuming and it costs a lot of money. So with that as an introduction, I will get started. Let's look at the first slide, please. The next slide, please. There we go. So let's talk initially about a will and about what happens to a person's property when that person is deceased. The first category is non-probate property, which passes outside of the will. So if this is what we're talking about, there's no reason to even consider going to probate court. Property that is owned with a right of survivorship, tenancy by the entirety, co-tenants, other things like that. The property passes immediately, instantly, upon the death of the decedent to the co-owner. And there's no need to go to probate or do any of that sort of thing. Joint bank accounts is an example of that. My wife and I have a joint account, and if I should get killed on the way to the courthouse, it would automatically be transferred to her, and there would be no reason to go to probate court. POD bank account stands for Payable on Death bank accounts that can be created at the bank so that when you pass away, the bank will transfer, without having to go to probate, the funds in the account to whomever you have named. Life insurance is property that passes outside the estate. It is governed by the contract itself, by the insurance policy. And the person who is named as the beneficiary, once again, automatically, upon the instant of death, the life insurance proceeds are transferred to that person without having to go through probate court. All right, let's talk about probate property, things that would pass through the will or intestate succession. Those items would require opening a probate account, and the best way to avoid that is by joint accounts or joint ownership. So once again, there's no need to go through probate. Life estates, another way to avoid probate and to avoid a last will and testament. The life estates are created while the donor is living, and the document is prepared, and it sets out what a person who's making the trust wants to happen to his or her property upon his death. And a trustee is named to see that all of that is carried out, and it goes outside of probate. And that can be a very good way to avoid probate. However, with many of our clients, there really isn't a need for a living trust, but it is a contingency that you should be aware of. Life estate. can be made contingent. And don't forget, if there is a contingent life estate, to address the remainder interest. But hopefully, even those things will be avoided, as we'll see as we proceed. Next slide, please. This is a simple will checklist that's not from a textbook or anything. It is something that I have compiled from meeting with these kinds of clients over the many years and the many decades. I'm not seeing it. There we go. So these are the simple will checklists or avoidance of a will checklist questions that would need to be answered. Number one, names and addresses of all family members, because we have to be aware of intestate succession. If the decedent dies without a will, then the state law for intestate succession will govern where the property goes to. Number two, in whose names are any bank accounts titled? And if they're in one person's name only, the advice to the client is to go ahead and set it up jointly so that it's transferred upon the instant of death. Are there any vehicles, and how are they titled? As with bank accounts, they can be jointly titled so that it's transferred immediately upon the death of one of the owners. Number four, in whose names are any insurance policies titled, and who are the beneficiaries? As we've already discussed, the insurance policy is governed by its terms alone and not by the probate court doing anything. So there should be advice to the client, if there is a life estate, to go ahead and change the beneficiary or make sure that the beneficiary on the policy is who you want it to be. Next, in whose names are any investments, pensions, etc., and who are the beneficiaries? That is just like the insurance policy. It's governed by the terms of the document itself. And the beneficiaries, the client needs to be told, need to be reviewed and make certain that the client has the people to whom she wants or he wants the property to pass named as the beneficiary. 6, whether any real property is owned and how is it titled? Once again, the simplest answer to this sort of thing is to put real estate in joint names. And that can be done by using a quitclaim deed. These forms are available at the office of the Shelby County Register. And it's simple to get one and fill in the names. It will need to be notarized by the grantor. And once that's filed with the Shelby County Register's office, there it is. And upon the death of a co-owner of real estate, it automatically transfers to the other owner. There is a need to procure a certificate of death to file with the Register's office to establish the death of one of the owners. Number 7, how do you wish to dispose of your property upon your death? Aside from what we talked about, a lot of times these folks say, well, I want everything in my house to go to A, B, or C, that kind of thing. And given the types of clients that we're dealing with, that rarely is a good reason to go to probate and incur the investment of time and expense to get it done. A lot of times I ask my clients, well, you want it to go to your children. Do you trust them to divide it and not get into a fist fight at your grave site? And if so, just prepare a written document. We can notarize it if need be, stating what you want to happen to those items. And I will also tell them, and try not to be too grim, after all, you're not going to care at that point. So, number 8, do you wish to leave anything to a child, a minor? If so, there's going to have to be a trustee named and a trust created for the minor child. Normally, those trusts remain in effect until a certain age, 22, 25, or whatever the grantor wants it to be, at which point the child receives the property. The trustee is named and given instructions on how to apply the trust to the needs of the child. All right, number 9, if we have decided that there's going to have to be a will, we need to get the client's advice on who he or she wants to be the executor, the person to go to probate court to prove. Probate means prove the will and carry out the instructions and make sure that all of the property is conveyed in compliance with the will. So if we can't avoid it, we do need to discuss who we want as an executor. Probate, aside from the time that it takes, the estate must remain open for at least 6 months so that notice to creditors can be given. Accountings are required to be filed unless they are waived in the will, so that keeping track of all the money and records and transfer of property falls to the executor, and he or she must file an accounting that satisfies the probate court judge that the contents of the will are being carried out legally. Number 10, we should always ask the client if the client wishes to have a durable power of attorney in effect for business affairs. And it is always excellent advice and an excellent choice to go ahead and do that. The power of attorney for business affairs can either be springing, which means it springs into effect when the grantor loses mental capacity, or it can be immediate, so that as soon as it's signed and notarized, the attorney, in fact, can go to the bank and clean out the bank account. So we rarely do immediate powers of attorney unless the grantor is hospitalized or around the bend and it needs to be done right now. But I would suggest to you very strongly that everyone needs to do this. No one knows the hour nor the day. No one can predict the future. And power of attorney needs to be in effect for business affairs, because if there isn't one and the client loses competence, then you're going to have to go to probate court and open a conservatorship and get somebody appointed to handle the business affairs. And that will remain in effect as long as the person who's lost competence is alive. It's expensive. There are requirements of accounting so that the court knows that everything's being done properly and all of that. So you want to avoid the risk of a conservatorship having to be created at some future date. Last on the list, the client should always be asked if he or she has advanced medical care directives in place. And if not, the client should be very strongly urged to do that. Because as I said about a power of attorney for business affairs, no one knows the day nor the hour, but we know it's coming. And the advance directive, it's grim. People don't want to think about it. A lot of times a client will say, well, I'll just let Jesus decide. So here's the approach I take with them. This can be one of the greatest blessings you can ever bestow on your family members or your friends who are called upon to make this decision, because you will have already made the decision. And having represented physicians in hospitals for over 40 years in Memphis, I've seen far too many examples where there is no directive in place and the nightmares can ensue. We'll talk about this a little more later, and we have the forms at the end of the presentation. Okay, next slide, please. This has to do with real estate ownership. If there's an issue about the real estate and in whose name it is, because the parents may have died and the child has been living there for decades, you need to go to the Shelby County Register of Deeds office, and you can do so online and enter the address or the owner name, and then you'll get electronically, you'll get the official records as to who owns the property and all that sort of thing. So if that issue arises, here is how to resolve it. Next, please. All right, we'll talk about probate a little more. I don't mean to be too repetitive. I've already stated that probate means to prove, and it is the court supervised process which takes place after someone dies with a will or intestate, where there's a requirement for the probate court to intervene and make sure everything's done properly. Proving the will entails proving the deceased person's will is valid. Now that can be very tricky, because a will like this is going to require two independent witnesses who are not related to the testator and have no interest in the estate. They will have to meet with the testator, as will the notary public. And then the witnesses will sign affidavits stating that they have witnessed the signature and all of that. So all of that is required before the will can be probated. There is a holographic will where the testator writes everything out in his own handwriting, not typewritten, and then signs and dates it. But you still have to have witnesses to attest that this is the testator's writing and not something done fraudulently. So that's what, no, I'm not quite ready yet. That's what, can we go back one? That's what is how you have to prove the will is valid. Then the executor has to identify and inventory the deceased person's property, have the property appraised, pay all debts and taxes, and distribute the remains as directed by the will or intestate succession directs. All right, now the next one. Who handles the process to see that all of these things are done? The executor, who is named in the will. If no executor is named, the court may or will appoint an administrator to carry out these duties. It's the responsibility of the administrator to track down property and accounts, to pay creditors, debts, taxes, and finally the beneficiaries. So in just a few words, that is the probate process. Next slide, please. You should certainly plan to avoid the probate process because it's rarely a benefit. It costs time and money, and it only really makes sense if they're complicated issues. For example, minor children, where a trust would have to be set up, or some other issue where everything can't be put in joint names or the proper beneficiaries named. Next slide, please. All right, a living trust is a means to avoid probate. Living trust just means that it's created while the donor is living, and it's not something that's created at death. The property that is transferred into a living trust before death does not go through probate. The person you appoint to handle the trust after your death transfers ownership to the beneficiaries named in the trust. There are no legal or court fees to pay. There's no requirement of accountings. And a few years ago, I lost a good friend who had established a living trust with my assistance. And after his death, it was just a matter of me going to the banks and showing them the document and my ID and collecting the money. I hired a real estate agent to sell the house. And all of that was done. Everything was collected and dispersed as he wished. And that was a very good way to do things. But once again, I'm not sure that the kinds of pro bono clients that we're dealing with will need something even this complicated. But it's good to have in mind should the need arise. All right. Payment on death designation, POD, which we've already meant. It can be assigned to checking accounts. If you'd rather not have someone with joint access to your checking accounts, you can go to the bank and say who you want it to go to upon your death. Savings account, certificates of deposit. By doing this, the grantor remains in control of the money until death. I mean, if it's a spouse or a family member or someone who's trusted, joint names or joint ownership. If there's any issue with that, here's the way to avoid it so that the grantor remains in control until the instant of death. And upon death, the payment on designation beneficiary can go to the bank and collect the money and do whatever else is necessary. All right. Affidavit of Airship. When a person dies without a will, the real estate will immediately vest in the decedent's heirs. The Affidavit of Airship serves as a notice that states who the new owners of the property are. The affidavit must be filed with the Register of Deeds, but need not be filed with the probate court because real estate doesn't go through probate unless it's intestate. So it's good to raise this with clients if there are a number of family members. And there's a potential for an issue upon death when there are 4 or 5 different people who have a claim. And we see that a lot, where one option is to sell it and split it up, and that's what half of them will want to do, and the other 2 will want to keep it. And you end up in court on something like that, getting a decision made. So if you file this ahead of time, these are my relatives, with the county register, then it names who has an interest and who doesn't. All right. Living trust disadvantages, there really aren't any if there's a sufficient amount of assets in the estate to indicate that a living trust is good. There are costs associated with transferring ownership of assets, but those are minor. There is no notice of the trust provisions to any of the beneficiaries, but that I don't see that as a major issue either. Next. Joint ownership, we've talked about. Joint tenancy with right of survivorship is what you share with a spouse. Tenancy by the entireties and tenancy in common. These are the other ways to affect joint ownership of various assets and property. Go ahead. All right, I've mentioned testamentary trust several times, and if there are minor children, that's problematic because joint ownership and all of that will not work with a minor. So a testamentary trust would be established by provision in a will. So there might need to be a will if there are minor children. This type of trust, as opposed to living trust, will establish the way to control and preserve assets until the child matures into a responsible adult. The age is picked when the trust will end. The trustee is often given duties in the trust to pay for the education of the child and medical expenses and all that sort of thing. So that's some of the bones of the matter. An individual is appointed in the will that sets up the trust to manage the trust for the minor. As beneficiary, the child is entitled to whatever income and principal from the trust that the trust document says he or she is entitled to. Hopefully we won't have to deal with that, but if we do, that's some basic information on it. And it would require a will. Next. Spendthrift trust. This is for somebody you want to leave something to, but they have issues with money or substances or something else. So this trust is created for someone whom the grantor considers to be irresponsible regarding money. Trustee who is named keeps control of the trust income and corpus, giving money to the beneficiary as necessary. So this will come up too with all clients. And if it becomes an issue, it needs to be discussed and perhaps consideration given to a spendthrift trust. Next, please. Okay, here are a couple of examples of typical clients that we might see at a pro bono clinic. The client is widowed and has 3 adult children. The client owns a house, personal property, a checking and savings account, and a life insurance policy. She wants the house to go to the youngest child who lives with her. And as it says at the top, all 3 children are adults. She wants her jewelry to go to a grandchild and the furniture to stay with the house, and the children can decide what to do with the rest of her personal property. She trusts her oldest child to make her financial and medical decisions. All right, first of all, as regards the house, she wants it to go to the youngest of her 3 children. Then a quitclaim deed should be created so that the youngest child will inherit the house automatically without need for probate upon the death of the client. So that one's pretty easy, but we should be aware, and we'll get about this, and we'll touch on this again later, but when we're talking about real estate, we should also always inquire if there is a mortgage, because that's going to be problematic. If you create a quitclaim deed granting the right of survivorship to someone and the bank or the mortgagor has an interest, it may not work. So that's something to consider as well. All right, this client wants her jewelry to go to a grandchild who I guess is a minor, but we don't know, and the furniture to stay with the house, and the children can decide how to divide the rest. So that can be a little bit tricky because we want to avoid a will. The jewelry is to go to a grandchild. Perhaps what should happen is that the jewelry should go to the grandchild's parents, to one of the 3 adult children, assuming the client trusts that person to make sure that it goes to the granddaughter. Now, that would be a lot easier. The furniture to stay with the house and dividing up the rest of the personal property. I've mentioned before that if the client trusts the children to do what she wants, maybe the thing to do is just to prepare a document. It's not a legal document, but it sets out what she wants done after her death. And if her children are going to respect and follow that, then it's taken care of. And once again, the client's not going to care. The next example, the client comes with her spouse. They've been told the state will take the house if they don't make a will. Each spouse has 1 child from a previous relationship. They jointly own a house, personal property, and a checking and savings account. So the house, once again, assuming there's no mortgage so that this can be done properly, it should already be, and if it's not, in joint names, so that upon the death of one of the husband or wife, the other automatically inherits everything without going through probate. In terms of everything going to the surviving spouse and then on to their own child, that's going to be problematic. Perhaps a living trust would be the answer to that one as a way to avoid probate. A document, a fairly simple document stating what the client wants done. And that could be done as well in the previous example with the jewelry and the furniture and all of that. So maybe that would be the proper answer to this one. They own a house, personal property, checking and savings account. The checking and savings account should be in joint names, and I think the answer to the rest of it is a very simple living trust. Next. Common issues that we deal with in discussing these topics with any client, but certainly with the clients we see at pro bono clinics. Testamentary capacity. If you reach the conclusion that the client doesn't have testamentary capacity, then you should tell the client that you can't do anything for them. Tell them what intestate succession provides and the alternatives. Healthcare, surrogate, representative payee, all of that. Now, let me digress for a moment. I carry in the trunk of my car the forms for advanced healthcare directives and for general durable powers of attorney for business affairs. In the notebook that contains those documents is my second notary seal, my extra notary seal. And I will go around town or to the hospital or to the facility or whatever and try to get these documents done and executed, because I've seen far too many times what happens when they aren't there. And when I'm meeting with a client and preparing to notarize a document, I assuage my conscience with the concept that I am not a neurologist. I am a notary. And I will err on the side of getting the document done and notarized unless my conscience just won't allow me because of the advanced condition of the person. So keep that in mind when you're talking about testamentary capacity or advanced directives or a general durable power of attorney. It's best to err on the side of getting it done than not. All right, another common issue, ownership. There's the website for the Register of Deeds so that you can check to see in whose name any real estate is titled. All right, next, lack of equity. Here we're talking about a mortgage that I've already alluded to before. Client owns a home evaluated or appraised at $40,000, but has $30,000 left on a second mortgage. Wants the home to remain in the family, but no heirs can pay the mortgage. So what's going to happen if she dies with that mortgage is that the mortgage company will take possession of the property and sell it. Perhaps the only solution in a circumstance like that is to go ahead and sell the property and divide the proceeds equally now, because the mortgage company is not going to stand for it if it has a 75% interest. All right, lack of cash. The client wants to leave $2,000 to a niece in her will. Her only income is Social Security, and she's got $200 in a bank account. Where will this $2,000 come from? And the simplest answer to that would be if there is a life insurance policy, to name the niece as a beneficiary, or put her on a bank account, or name her as payable on death beneficiary of a bank account. The last common issue set out here is separation. Client's been separated from the spouse for 15 years, never divorced. Client very unhappy to hear about the elective share, and that's part of intestate succession, where the spouse gets a percentage interest of the estate if there is no will. There's some good news about that, because the eclectic share is not automatic. The spouse claiming would have to hire an attorney and go through the probate process to claim the elective share. Or the client could go ahead and finally get a divorce to remove the elective share possibility. Next. All right, now let's talk about advanced care directives, as we already have. The goal is to have someone appointed to make end-of-life treatment decisions. Adults should always do it to make sure that their wishes are met, and as I've already said, to take the burden off the family member upon whom the decision will be put at the end of life. Capacity standard: the declarant must be able to understand and appreciate the nature and consequences of it. Now, back, please. The nature and consequences of a decision to accept or refuse treatment. So that's another capacity issue that you, as the notary, would need to consider. Once again, err on the side of getting it done. Next. I'm not next slide, further down here. Now, there's a witnesses at the bottom. Can we get to that? Let me just talk about it then. The best way to do the advanced care directive is to simply notarize it. It can be witnessed, as we'll see on the form, but the witnesses cannot be relatives, cannot have any interest in the estate. If the client is in a hospital or a healthcare facility, their employees are not allowed to serve as witnesses. So blessedly, the alternative is simply notarization, and that's how to do it. Okay, next. Now we're looking at the form, and I hope you can see it perhaps better than I can. At the top, and form is promulgated by the state of Tennessee. At the first top blank would be where the name would be filled in of the person granting or naming persons to carry out the directives. Below that is the spot for agents, and a name, address, relationship, all of that is to be filled out. Doesn't have to be typed. And these forms are a little bit dated, so I always, when I'm doing this, try to get email addresses, like every possible way to reach the potential agent should the need arise. Below that is an alternative agent, and it's always best to have an alternate in case the first choice is not available or is unwilling to do it. Then there's the when effective section just before the dark line all across the page. And this is where we talked about either springing into effect when the person who's filling out the document loses mental capacity, or immediate, effective immediately. And that depends on the circumstances, but it's rare to need an immediately effective advance directive. All right, now part 2 gets complicated, and this can be difficult to go through with the client. So it's important that you have an understanding and can explain it. The first section is quality of life. And below that, with the yes or no check marks, are 4 qualities of life. The first one is permanent unconscious condition, a permanent coma. This is not based on speculation. This is based on the doctor's diagnosis. If you're in a permanent coma and you're not going to awaken, is that acceptable? Yes or not? No. The second quality of life, permanent confusion, advanced dementia, and all that, which is not going to improve. Is that acceptable to you or unacceptable? Then you need help doing everything, going to the bathroom, getting fed, all of that. You can't move or do anything for yourself. Is that something that you want or something that you don't want? And then you have end-stage illnesses. You are dying of cancer, per the doctor's diagnosis, and you have a heart attack. Do you want to be treated for that, where you're only brought back to dying of cancer? Is that acceptable or not? So I suggest to clients, I tell them I've had one of these for decades, of course, and none of these qualities of life are acceptable to me. So for whatever it's worth, I have checked no to all of them. Then we get treatment wishes, and it's important to make the client understand that this section refers back to the qualities of life. So the first one is cardiopulmonary resuscitation and all of that. You are in a permanent coma and your heart stops. Do you want to be resuscitated or just let it go? And you check, yes, I want to be treated, resuscitated, or no, I don't. Then we have life support, and other artificial support is the only thing that's keeping you alive when you have advanced permanent dementia and don't know who you are, what's going on, or who anybody else is. Do you want that treatment or not? Treatment of new condition, sort of already alluded to that. You're in a permanent coma and you have a heart attack. Do you want to be resuscitated or not? And then really have tube feeding and all of that is the only thing that's keeping you in a quality of life that you've already checked as unacceptable. But I tell the clients too, that's for what it's worth, in my form, all of these are checked no. If I'm in an unacceptable quality of life, I do not want to be brought back to that, where I'm just going to stay in a coma or continue to die of terminal cancer. But it's up to the client. There can be no more personal decisions that a human being makes. But if you have a client who says, yes, I want yes on all of these, then you can just stop and tear up the form and say, well, that's what's going to happen automatically. You will be kept in a permanent vegetative state forever, unless you fill this out, because that's what's going to happen. That's the fallback for the medical profession and society in general. There is another document, as it's suggested on the right, Suggest a Living Will, what is more commonly known as appointment of a healthcare agent. This one is preferable, but it can be difficult and tricky. The client can simply appoint an agent to make healthcare decisions. The problem is that the client has not already made the decisions, but at least someone is named to wrestle with it and to try to do what the client would want. And that's far better than nothing. So this is option 1. Appointment of a healthcare agent is option 2. Next page. There's a place at the top for any other instructions, which doesn't have to be filled out, but it can be. Then there's a place for organ donation. I always tell the clients that you're probably like me. You think you're too old and beat up for any of your organs to help anyone. But if nothing else, the corneas of our eyes could restore someone's vision. So don't just blow that off. Then there's the place for the signature of the person naming the agent, and then the date. Block A is the place for the witnesses. We're not going to do that. It's too complicated. And if the witnesses don't totally comply, and you might be having to bring them with you to the intensive care unit or something, then that's not going to work. Very bottom, block B, the place for a notary public. That's it. There are some instructions or suggestions at the bottom about what to do with the directive. Give the original or certainly a copy to the person who is named. who is not named, I'm sorry, and make sure it's in your medical chart, your doctor has it, and that if you're hospitalized, it's in the hospital chart. Make sure that friends and family know where it is if the need should arise, and make sure your friends and family know what you want done so that even if the document is not found, your wishes are likely to be carried out. Okay, next, please. This is more on advanced care, which in the past, this form was called a living will, but now it's advanced care directives. It can be revocated if you decide you want to do something different later. It can always be changed. If you're hospitalized or being treated by a physician and lose competency, there are other methods of having someone appointed or named to make decisions, but that's to be avoided if possible. Surrogate consideration, first spouse, then adult children, parent, adult siblings, and any other relative. A doctor can only serve if he or she is related to the patient or with the approval of the ethics board of the hospital. Next. This is the power of attorney for health care, which I've already alluded to as the naming an agent, healthcare agent. And it's name someone to make the decisions, but the decisions are not already made by the patient. Capacity standard, the principal reasonably knows and understands what's going on, and those sort of things. This is the second step if the first step that we went through in some detail doesn't work. Next, please. Power of attorney, once again, naming an agent. And that's, if you should need a form, I can certainly provide them to you, but I think we've already covered this. Let's go on. This is the power of attorney for healthcare decisions. The form that the state promulgates for naming an agent is simpler, but this is also available if you, for some reason, this is what's needed. Next page, please. This is where the agent is appointed and the document is signed. Next. Attestation, signature of a notary public. Once again, no witnesses, that's not going to work. It's got to be notarized anyway. So let's just notarize it. Next page, and we're nearing the end. I'm sure you're happy to hear. This is a power of attorney for finances and business decisions. And it names someone to handle business affairs and all of that sort of thing. Capacity standard. You don't want the person who's giving the power of attorney to be taken advantage of by children or relatives or something. So there is a requirement that you reach the decision that the client has the capacity to do it. Excuse me. Next slide. All right, and here is the form. This too can be immediate. There's a need to be making business decisions immediately, or springing, when it becomes effective upon the grantor losing mental competence. Fill out the name and the address of the person naming the attorney in fact. Below that, the name of the agent. And down at the bottom, there's a blank where an alternate agent can be named. And I usually do not go through all the legal language on the first page of this. I just make it clear to the client that this document says that the person you appoint can handle anything that might come up. It has antique legal terms, bottomaries, hypothecations, all that sort of thing. But there's no reason to plow into all that as long as the client knows that anything that arises can be dealt with. Next. This is where the other blanks are filled in. That's where an alternate can be named. And then the signature of the principal and the date And then finally at the bottom, the notary public. And with this document, the original should be given to the person named as the attorney in fact, and copies should be kept on hand. All right, is that the last slide? Now, limited durable power of attorney. This is the one that springs into effect in the future when and if it's needed. And I don't think we need to go through all the language there. We'll go to the next page. And once again, it's pretty clear. Each page does need to be initialed. You'll see at the bottom left. And then the last page is where it is signed and notarized. Is that the last slide? I think it is. All right. Well, I'm happy to have made it. And I think we've reached 45 minutes or so we should be in good shape. I do have all of these forms. I think I've provided a lot of them to Constance and Ashara. If I have not, I will. And we will make sure that if you need something that we've discussed here today, that we can be of further assistance. Thank you, as always, for your involvement in pro bono work. What a lawyer can offer that no one else, no other human can offer, is the ability to take away the burden. And it's vitally important that we carry out that role as we do. And with that, I'll quit talking.
Thank you so much for that very informative seminar. We have a list of common questions that we received from clients. You have covered them, but for the most part, most of them were covered, but we still want to just take an opportunity to ask them. Shakara has about 3, and I have 1. My 1 is just, is there a need, in your professional opinion, for a person to have an advance directive and a healthcare power of attorney in place?
No. The advance directive, the more complicated form, covers everything. It's only if the client doesn't want to do that, wants Jesus to decide or whatever, that the secondary option of naming an agent to make healthcare decisions is needed.
Okay, my questions are, the first one is, what exactly needs to be done in order to edit a will?
It has to be redone. You can't just make little changes. It has to all be redone. Once again, you have to get 2 independent witnesses and a notary and jump through all those hoops. But unfortunately, that's the only answer. If someone has a will and things have changed and they're not happy with it, you just have to start from square one.
Okay. And I think you did mention this, but you said to leave a copy with the attorney and, make sure your family members know where it is.
Yes.
But let's say the only copy was with the attorney and the attorney has passed. So would they need a new will?
Yes. Yes. That's why it's important to have copies. And beyond that, why it's important that all friends and family know what you want. Because if the issue arises and everyone's in agreement, then what you want is going to be done. But it's important to have copies. And the first form, the more complicated one I suggested, as it suggests in those last few lines on the bottom of the last page, make sure that there's one in your chart at your doctor's office. Make sure that there's one in the hospital if you're admitted to the hospital. All of that. Far better to have too many than too few.
Gotcha. And then the last question is, so with the joint account, if someone new is added, will they have access to the money immediately?
Yes. Yes. And I mentioned that could be problematic, and you might want to do it that way. Might not want to do it that way. So the payment on death, POD, you can go to the bank account and say, I want to name this person to receive my account when I'm dead, but not to have immediate access to it. And that would be done at the bank, by the bank, so it's not complicated.
Okay, that's all I have.
All right. Okay, then I guess we're done.
Well, again, thank you so much, David. We really appreciate you. Thank you for kicking off our Pro Bono Month event. And everything that you mentioned today was very, very, very helpful. And it's going to help a lot of clients. And that's what we are all here to do, help as many people as we can. So thank you.
Absolutely. Thank you for
David.
asking. All right. Bye.